Thank you all for attending today's HIPAA training session. During today's presentation, we're going to go over some of the key concepts in HIPAA privacy and security. We'll start off with some general regulatory background to help put the law and its regulations into context for you before we move into a more targeted discussion of the HIPAA privacy and security requirements themselves. I'm also going to dedicate some time to going over the breach notification requirements under HIPAA, which are quite prescriptive and important to understand. I'll finish the presentation by talking a bit about the current regulatory climate and why compliance with HIPAA is so important. There are really two major laws underpinning HIPAA requirements as we know them. First and foremost, there's the Health Insurance Portability and Accountability Act, which was passed back in 1996. This law was the basis for HIPAA as we generally know it today. In 2009, the Health Information Technology for Clinical and Economic Health Act, or HITECH for short, was passed, and this act made the first set of really substantive changes to HIPAA requirements since the original law had been passed in 1996. In particular, HITECH modified existing requirements to increase oversight activities, to strengthen breach reporting requirements, and to increase penalties for noncompliance with HIPAA's provisions. Underlying every major law is a set of implementing regulations. The privacy and security rules were the two major regulations issued pursuant to the 1996 law. Most of the time when we talk about what HIPAA requires, we're referring in large part to the provisions of the privacy and security rules. The HIPAA enforcement rule was initially issued in 2006, and after HITECH, a final omnibus rule was promulgated in 2013. This omnibus rule consisted of 4 separate regulations implementing HITECH's provisions. These were updated versions of the privacy, security, and enforcement rules, and a breach notification rule. So who does HIPAA apply to? At a high level, HIPAA applies to several different types of covered entities and business associates. But I'd like to focus on employer-sponsored health plans because that's why we're here today. First, it's always important to keep in mind that the health plan itself is the covered entity, not the employer. But because a health plan only exists on paper, the employer, who is the entity sponsoring the plan and is the entity with employees, becomes, practically speaking, the entity responsible for ensuring compliance by its health plan. So when we think about who needs to comply with HIPAA, we have the technical answer, which is the health plan, but then we also have the practical answer, which is the employer sponsoring the health plan. In addition, many types of group health plans are subject to HIPAA. It's not just the medical plan. It's also important to look at dental plans, vision plans, prescription drug plans, etc. Also, the employer's size doesn't matter. HIPAA applies to all group health plans. There's one limited exception for group health plans that both have fewer than 50 participants and that are self-administered, meaning there's no third-party administrator. Most group health plans are administered by a TPA or are fully insured, so this exception doesn't apply in too many cases. Before we dive into privacy and security requirements in detail, I think it would be helpful to make sure we're clear about what we talk about when we talk about PHI. First of all, PHI stands for Protected Health Information. It's a term specific to HIPAA. The definition is actually quite technical and long, but the easiest way to describe what PHI is that it's individually identifiable information, for example, a name, a date of birth, a social security number, that is related to the employer's health plan. And by related to the health plan, I mean information that is created, received, or maintained by the plan. This would be things like enrollment information, benefits plans, claims information, etc. Here, the main point is that PHI does not just refer to detailed claims information or just to treatment or diagnosis information. Any individually identifiable health information that has been created, received, or transmitted by the health plan should really be considered PHI. Now, this being said, it's important to understand what information is not considered PHI, since employers handle individually identifiable information for many different purposes. In short, any information that the employer holds in its capacity or role as employer is not considered PHI. For example, information related to FMLA administration, payroll information, workers' comp information, results of drug tests for hiring purposes. This is all individually identifiable, and some of it is health information too. But because it didn't come from the health plan records, or shouldn't have come from the health plan records, and because it's being used for purposes completely separate from health plan administration, the information is not considered PHI. In general, the rule with respect to disclosing PHI is that unless the use or disclosure is permitted or required by law, it's necessary to get authorization from the individual who's the subject of the PHI first. So, what is permitted or required by law? First, HIPAA recognizes that employers sponsoring group health plans need to access PHI in order to properly administer their plans. For this reason, HIPAA carves out an exception for what is called treatment, payment, and healthcare operations. This exception allows covered entities to use and disclose PHI for purposes of plan administration, for example, to pay claims, process enrollment, etc. Therefore, PHI may be used for these purposes without first obtaining written permission from the individual. In addition to plan administration, there are certain other exceptions carved out in the law for use and disclosure of PHI without written authorization. These include things like disclosures in the case of public health emergencies, disclosures for judicial or administrative proceedings, disclosures to law enforcement, and so on. If a particular use and disclosure does not constitute treatment, payment, or healthcare operations and is not otherwise specifically permitted or required by law, then it's necessary to obtain written authorization from the individual who is the subject of the PHI first. We talked before about how individually identifiable information that the employer holds in its role as employer wouldn't be considered PHI. An employer's role as plan sponsor of a group health plan and its role as employer are separate. For this reason, it isn't permissible to use individually identifiable health information, or PHI, for any employment-related purpose. For example, an employer couldn't pull claims information from its health plan records regarding an employee's substance abuse treatment, and then use that as a basis for firing that employee. This would be using PHI for a non-health plan related function. And without written permission from the individual, this type of use is not allowed. It is important for employers to consider where individually identifiable information is coming from and what it is being used for. If it comes from the employer's health plan records, then it may only be used for plan administration, not for functions the employer is carrying out in its role as employer. So what does it mean to use PHI for purposes of plan administration? Typically, plan administration involves things like claims adjudication, assisting with post-enrollment benefit-related questions, and perhaps working with auditors on compliance-related issues. It may also involve things like systems maintenance and oversight by certain members of the IT department. It's important to ensure that employees who are involved in carrying out plan administration functions are identified and that PHI is only made available to those employees. In general, we see individuals in human resources, benefits, payroll, and perhaps IT having access to PHI. Conversely, the CEO or vice president of sales typically doesn't have any reason to access or see PHI as they aren't involved in plan administration, and the request likely wouldn't be for a plan administration function. So what are some common ways that employers ensure that their PHI remains safeguarded and safe from unauthorized access or use or disclosure? There are no prescribed safeguards in the privacy rule, but this is a list of some of the more common approaches we see companies adopt. Shredding papers containing PHI instead of simply tossing them into the wastebasket. Making sure all PHI is stored in locked filing cabinets and that the key to those filing cabinets is its access is controlled. Locking computer screens when left unattended. Positioning computer screens that display PHI away from others. Refraining from discussing PHI in areas where others can hear. Not writing or sharing passwords. Making sure that if you get a request from somebody about their own PHI, that you're verifying what their identity is before you make that disclosure to ensure that they really are the person they say they are. If faxing PHI, using confidential cover sheets. If emailing PHI, using a secured encrypted method. So now I want to talk about another important concept under the privacy rule, and this is the concept of minimum necessary. This is the idea that even when use of PHI is appropriate, an individual should still ensure that only the minimum amount of PHI necessary to accomplish the task at hand is used. For example, if a question about a claim can be resolved without sharing any diagnosis information, then that information should be excluded. Think before forwarding email strings that may contain PHI. Is the information in the email necessary to include for purposes of answering the question? Paying attention to the minimum necessary standard helps protect individuals' information by limiting its exposure and also provides protection to the plan sponsor as there is a reduced risk of an unauthorized disclosure or breach occurring. So what happens when a plan sponsor wants to access, use, or make a disclosure of PHI for purposes that aren't considered TPO and that aren't otherwise specifically allowed for in the law? For example, making a disclosure about an adult to a family member, or using PHI for an employment-related function like FMLA administration. If the use and disclosure isn't otherwise permitted or required by law, then it's necessary to get written authorization from the individual who's the subject of the PHI first. So perhaps an employee wants you to talk to his brother about his claims issues or benefits. Or perhaps spouses want to ensure that they can each access detailed PHI about the other. There are specific content requirements needed in order for an authorization to be considered valid. For example, the authorization must have a stated purpose for the disclosure, it must clearly identify who the disclosure may be made to, and what information may be disclosed. The company must have a process in place for procuring written authorization before disclosures that aren't for plan administration or that aren't otherwise permitted by law are made. So where do use and disclosure issues typically arise for employers? We typically see issues arising when it comes to employees or spouses looking to resolve claims issues related to another adult dependent on the plan. For example, an employee might call in about a spouse's claim, or a spouse might call in about an employee's claim, or a spouse might call in about an adult child's claim. In each of these circumstances, because the request is for a disclosure of an adult's PHI to another adult, it's necessary to ensure that authorization is put in place before the disclosure is made. As part of an organization's use and disclosure policies, there should be a process in place to verify the identity of a caller to ensure that the requested use and disclosure is allowable or appropriate. If you're not sure whether a particular use or disclosure is permissible, it's always best to reach out to your privacy official to confirm instead of trying to guess. So let's talk for a minute about the role of privacy official under HIPAA. In general, the privacy official is the person responsible for overseeing implementation of the company's privacy policies and procedures and for ensuring compliance with them. The privacy official is also responsible for acting as a point of contact for questions about uses and disclosures of PHI, investigating and responding to known or suspected breaches, responding to individual rights requests, and overseeing development, maintenance, and distribution of the Notice of Privacy Practices, which we'll talk more about in a bit. The privacy official may delegate certain responsibilities to others, but that role still maintains the responsibility for ultimate oversight. All right, so we've spent some time on use and disclosure rules for PHI, but another important part of HIPAA privacy is understanding what rights individuals have with respect to their own PHI. At a high level, individuals have the right to access their PHI, to amend their PHI, to receive accountings of disclosures of their PHI, to request restrictions and confidential communications of their PHI, and to make complaints about how the health plan uses and discloses their PHI. These rights are communicated to individuals in the company's Notice of Privacy Practices, and companies must have processes in place to receive and respond to any requests to exercise these rights. The Notice of Privacy Practices is an important obligation for covered entities under HIPAA. This is the notice that describes the ways in which the plan uses and discloses PHI, and it also tells individuals what their rights are, and these are the rights we just discussed, with respect to their PHI. The notice must be distributed directly to plan participants upon enrollment and whenever material changes are made. The notice must also be made available upon request, and a reminder of the notice must be issued every 3 years. For fully insured plans, the carrier may assume responsibility for providing this notice, but the employer is required to issue a notice for any of its self-funded plans. HIPAA requires that organizations put written policies and procedures in place that describe how they comply with the requirements of the privacy rule. These can and should be updated as procedures change or if other operational or regulatory changes are made that impact the content of the policies. HIPAA requires that anything required to be documented under HIPAA be maintained in written or electronic form for at least 6 years from the date of creation or the date the document was last in effect, whichever is later. It's important to ensure that organizations incorporate HIPAA's requirements into their overall record retention policy. In understanding HIPAA, it's important to understand the role and responsibilities of business associates. In general, business associates are third parties who assist in carrying out some type of plan administration function and who require access to PHI in order to perform this service. Business associates include third-party administrators and cloud services providers. They may also include lawyers, payroll vendors, shredding vendors, and other types of third parties. Before disclosures of PHI are made to any third party, a compliant business associate agreement must be executed. A business associate agreement requires that the business associate agree to safeguard the covered entity's PHI from unauthorized access. Covered entities must review their arrangements with third parties in order to determine whether or not a business associate relationship exists. And if one does, the covered entity should ensure that a compliant business associate agreement is in place. HIPAA also requires that any workforce members who are responsible for plan administration and who have access to PHI for that purpose be trained on HIPAA privacy and general security principles. In addition, all employees should be trained on general security awareness, and the employer's security expectations and requirements should be communicated. The privacy and security officials will collaborate to develop and disseminate training as appropriate. Before we move into the security portion of the presentation, I want to end with a note about HIPAA's prohibition on retaliation and waiver of rights. HIPAA prohibits employers from retaliating or intimidating employees or individual participants with respect to exercising their individual rights under the law. In addition, employers may not take any retaliatory action or otherwise threaten, coerce, discriminate against any individual for exercising their rights under HIPAA or for making complaints with HHS, participating in investigations related to HIPAA, or opposing in good faith any act or practice that the participant believes is unlawful under HIPAA. So moving into the security rule. Where the privacy rule was concerned about proper uses and disclosures of PHI, the security rule is really focused primarily on ensuring that electronic PHI is kept confidential, that it remains available, and that it's protected from unauthorized modification or destruction. The rule contains a set of 22 standards that all covered entities need to address. They address these things through completion of what's called a risk analysis, which compares the company's existing security controls to HIPAA's requirements and identifies any gaps and needed remediation. One important thing to keep in mind with respect to the security rule is that there is a lot of flexibility built in. Although the requirements are the same for all covered entities, the way they choose to implement them may differ significantly based on the organization's size, flexibility, mission, and purpose for using the PHI. For example, a large hospital system's compliance with HIPAA's security requirements will look very different than that of a mid-sized employer sponsoring a medical plan. The security policies are where the employer documents how it is addressing the various security rule requirements. You'll see here a list of items that must be addressed in an organization's security policies. In many cases, employers already have existing policies in place to address many of these items. For example, many companies have some kind of acceptable use policy in place, or sanctions policy, or password management policy. The goal here isn't to duplicate what employers already have in place, rather to make sure that any existing processes account for ePHI at an acceptable level of risk, and that they are either described or, if documented elsewhere, referenced in the HIPAA security policies and procedures. So let's talk about the role of the security official. The security official essentially fills the same role as the privacy official, but with respect to security. That is, the security official is responsible for overseeing development and implementation of security policies and procedures, facilitating the risk analysis that we just spoke about, and acting as a point of contact for any security-related issues or concerns as they relate to ePHI. Like the privacy rule, the security rule also requires that organizations train their staff on security awareness. The security training is required for all employees in an organization. Most companies already have some type of corporate general security awareness program training in place that they can leverage for purposes of meeting this HIPAA security requirement. There's no prescribed timeline for training, but generally training should be provided on a regular, for example, an annual basis, and periodic reminders and updates should be sent out in between more formal trainings. While a company's corporate security training is going to cover security awareness principles in more detail, this slide just goes over some of the more basic security awareness principles that we like to point out to educate people on basic safeguards with respect to ePHI. For example, again, not sharing passwords, not opening emails from unknown sources, not opening emails with attachments, even from known sources if you're not sure what the attachment is, Making sure that you understand and that you follow your company's acceptable use policy. Making sure your computer is regularly updated and that your antivirus software is running. Never trying to access EPHI through an unsecured network. And not downloading any software that isn't approved by your IT department. So now we'll spend some time talking about breaches under HIPAA. At a high level, a breach is any unauthorized use or disclosure or access of PHI. The threshold for determining whether or not a particular use or disclosure is a breach is quite low. Breaches are assumed to have occurred if there is an unauthorized disclosure, unless a plan can demonstrate that there was a low probability that the PHI was compromised. And they do this by applying a 4-factor analysis to the disclosure. Specifically, organizations must look at the nature and the extent of the PHI involved, who the PHI was disclosed to, whether the PHI was actually viewed or accessed, and the extent to which any risk to the information has been mitigated. So this is the analysis that must be applied to any unauthorized use or disclosure in order to determine whether or not a breach truly occurred. If a breach did occur, then there are specific notification requirements that must be met. First, individuals who were affected by the breach must be notified within 60 days. For smaller breaches, covered entities must log the breaches and submit an annual report to HHS. For larger breaches, those involving more than 500 individuals, the entity must notify the media and HHS within 60 days, along with the individuals. So why does HIPAA compliance matter? HIPAA is enforced by the Department of Health and Human Services, Office of Civil Rights, or OCR. Historically, enforcement of HIPAA has been very complaint-driven. OCR or HHS would step in when it was made aware of an issue that needed to be looked at, but wasn't necessarily out proactively monitoring organizations' compliance efforts. This changed after the passage of HITECH, which increased enforcement of HIPAA. Now HHS, or OCR, is required to conduct periodic compliance audits. Phase 2 audits of covered entities and business associates have just wrapped up. The penalties collected will be used to finance additional enforcement efforts. And as we noted before, HITECH significantly increased the potential penalties that organizations face for noncompliance. Violations of the company's HIPAA security policies should be reported to the security official or their designee. The privacy official shall receive and investigate all complaints regarding its HIPAA privacy policies. And workforce members should know that failure to follow the company's policies may result in disciplinary action. So to sum up, what are the expectations that we hope you take away from today's presentation? First, take privacy and security seriously. Report any potential breaches. Understand your corporate policies and procedures and follow them. If you have questions about what those policies and procedures or expectations are, ask. And specifically with respect to uses and disclosures of PHI, if you're not sure whether a particular use or disclosure is appropriate, check with the privacy official first. Thank you all for your attendance.